If you are a bankruptcy lawyer, and if you are lucky, you will never have a case involving the state's sovereign immunity. That's the topic of this week's installment of Rochelle's Daily Wire video edition. The problem began in 1996 with the Supreme Court's seminal decision in Seminole tribes. The dissent in that case pointed out how the majority's opinion very well might mean that the federal bankruptcy courts, or district courts for that matter, simply had no power to affect the states in a bankruptcy case unless perhaps the states were to file a claim. That statement, of course, thank goodness, was dicta, but nonetheless, it was pretty scary. Evidently later, the Supreme Court realized the mess they had made and in a couple of subsequent cases began to backtrack. Well, if this problem comes up, I have a solution for you in understanding the law. Read a decision in late July by Bankruptcy Judge Christopher Sontchi in Delaware. His opinion in the La Paloma generating case is a marvelous scholarly analysis of everything you need to know about sovereign immunity and when that defense, or actually it's more than a defense, it's a jurisdictional argument by a state, will or will not work. Not to spoil the pleasure you will have in reading the opinion by Judge Sontchi altogether, suffice it to say that if the issue is clearly one under the bankruptcy court's in rem jurisdiction, then there is not a sovereign immunity defense. Nonetheless, if you have time this year only to read a few opinions from bankruptcy judges, this one by Judge Sontchi in Paloma Generating is one that you need to read. That's what we have for this week. This is Bill Rochelle, ABI's editor-at-large, saying bye-bye until same time next week.